The letter came on a Tuesday in March. White envelope, corporate return address. Dennis Carver set it on the kitchen table and opened it with the same letter opener he'd used for 20 years. Inside was a single page, 2 paragraphs, and a number that didn't make sense the first time he read it. New annual cash rent, $390 per acre, effective the following lease year. He'd been paying $285. He did the math in his head, then pulled out a calculator anyway. 200 acres times $140, $136,800 in additional cost per year. He set the calculator down and read the letter again. Then he folded it and put it back in the envelope and went to make coffee. This was not panic. This was calculation, and the numbers were already very bad. Dennis had farmed this ground for 23 years. The land sat in the rolling corridor between 2 river valleys in central Illinois. Corn and soybean ground, deep topsoil, good drainage, the kind of farmland that gets quietly bought and sold at a premium, while the people working it don't always know it's happening. He'd rented from the same family trust for most of his adult life. The prior owners had been local, one phone call if there was a problem. Fair increases when they came, never more than CPI. Then, 14 months ago, a company called Meridian Agricultural Holdings LLC acquired the entire portfolio. 17 farms across 4 counties. The announcement came through a 2-paragraph notice from a law firm in Chicago. The Carver farm was Parcel 7. Cash rent doesn't care about loyalty. He'd kept his head down, kept farming, kept paying. His operation ran on a combination of owned equipment, a working line of credit from First Ag Bank, and the kind of margin that only makes sense if you know how thin it actually is. On a good year, good yields, decent basis, reasonable input costs, he cleared somewhere between $60 and $75 per acre. On 200 acres, that was $72,000 to $90,000. Enough to cover his family, service his equipment loans, and put a little back. Now do that math again. $136,800 in new cost, against a margin of $60 to $75 per acre gross. The math didn't work, not even close. He called his lender first, not because he was panicking, because he needed to know exactly where he stood before he did anything else. Tom Hensley at First Ag had been his relationship banker for 11 years. They met in person at the branch office on a Thursday morning. Tom had already pulled the numbers. "Walk me through what I'm looking at," Dennis said. Tom slid a printed sheet across the desk. Debt service coverage ratio. The bank required a minimum of 1.25, meaning for every dollar of debt service, Dennis needed to show $1.25 in available cash flow. At his current rent, he was running just above 1.3 in a normal year. Tight but bankable. Under the new rent, assuming average yield and average price, the projection showed 87. "That means the operating line doesn't renew," Tom said. He wasn't being harsh. He was being accurate. "If I take your projected cash flow to committee at 0.87, they won't approve the renewal. And without the operating line, you can't buy inputs for the spring. When do you need the decision? If you're not signed or in active negotiation by July, I'd have a hard time arguing for the renewal in September." Dennis picked up the sheet, looked at it for another moment, then folded it and put it in his jacket pocket. "I'll be back before July," he said. "Debt service ratios don't adjust for surprise." The hedge fund, because that's what Meridian was, a fund with agricultural land as the asset class, scheduled a tenant meeting for early April. 40-some farmers from across the county sat in folding chairs in a rented conference room at the Holiday Inn off the interstate. A man named Garrett Bryce ran the meeting. He was professional, measured, spoke in the vocabulary of institutional investment. Rent adjustments were described as portfolio-wide recalibrations to reflect current market rates. He showed a slide with comparable cash rent data from recent transactions in the region. The numbers weren't wrong, market rates had moved. That was real. What he didn't say was that market rate and break-even aren't the same thing. After the presentation, there was a Q&A period. A few farmers pushed back. One man, older, ground he'd farmed since his 20s, said he was going to have to walk away from his lease. Garrett Bryce nodded sympathetically and said the company would work with any tenant in a difficult situation on a case-by-case basis. That was the false hope. Dennis recognized it for what it was. After the meeting, Bryce approached Dennis specifically, said Meridian had reviewed his parcel, recognized his long tenancy, and was willing to have a conversation about a more gradual transition to market rate, perhaps a 2-year phase-in instead of immediate implementation. Dennis thanked him and said he'd be in touch. He drove home thinking about that phrase. Gradual transition. 2 years of pain instead of 1. The math still didn't work at the end. Would you sign a 40% increase? Most of the farmers in that room were going to. Because what's the alternative? He almost signed. That's the honest truth of it. 3 weeks after the meeting, he had the lease amendment on his kitchen table. Bryce had sent a revised version, slightly softened language, the 2-year phase-in included. It was still $309.89 per acre at full implementation, but it bought time, and Dennis was tired. Spring was coming. He had ground to plant. He picked up a pen, held it for a long moment. Then he set it down and went to the filing cabinet in the back room instead. He'd been meaning to organize those files for years. Lease records going back to when he took over the operation. Equipment purchase agreements, crop insurance documents, soil sampling records. He didn't have a specific reason to go through them. It was more like a reflex, the same instinct that made him double-check yield maps before making marketing decisions. Before you sign something new, you read what you already signed. He pulled the original lease agreement, 1999, his first year on the ground, 12 pages. He read through it slowly, page by page, the way he hadn't read it in years. Standard cash rent terms, annual renewal provisions, escalation language tied to a local appraisal benchmark. On page 9, there was a paragraph he'd read before, but never spent much time on. It referenced an exhibit attached to the deed of record, Exhibit C, described as the 1968 Master Agricultural Lease revision for the original farm parcels. The language said this exhibit and its terms were incorporated by reference and ran with the land. He read that sentence 3 times. Ran with the land. He went back to the filing cabinet and found the property abstract his attorney had prepared when he first signed the lease. He wasn't sure what he was looking for, but he found a reference to the same exhibit, Exhibit C, recorded in the county deed record, Book 214, page 37. He called the county recorder's office the next morning. The original document, when it arrived as a scanned PDF, was 42 pages long, typed on what looked like an IBM Selectric formal legal language dated September 1968. It had been drafted when the original farm was assembled from 3 smaller parcels following an estate settlement. The attorney who drafted it, a man named Raymond Holst, whose firm no longer existed, had been thorough. Section 11 covered rent adjustment. It established a framework for periodic rent review tied to a specific index, the U.S. Department of Agriculture's published cash rent survey for the county. Adjustments were capped at the percentage change in that index over a rolling 3-year average. Increases above that rate required either tenant consent or a showing of material change in land productivity or improvements. The language was precise, it wasn't ambiguous, and according to the abstract, it had been recorded continuously in the chain of title since 1968, through every sale, every transfer, every refinancing, including Meridian's acquisition 14 months ago. Ownership changes, paper stays. Dennis sat with that document for 2 hours. Then he called an attorney. Margaret Sell ran a 3-person general practice in the county seat. She handled estate work, farm transactions, some litigation. She wasn't a specialist in agricultural leasehold law, but she knew deed records and she knew how to read a contract. She told Dennis to bring everything: the original lease, the abstract, the 1968 document, the amendment Meridian had sent. He drove to her office on a Wednesday afternoon and sat across from her while she read. She took 40 minutes. When she looked up, her expression was careful, not excited. "The clause is real," she said. "It's recorded. It's in the chain of title." She pulled up the county GIS records on her computer and confirmed the parcel numbers matched. This is what's called a covenant running with the land. When Meridian bought this portfolio, they took title subject to all recorded encumbrances. Their title company would have found this. Would they have read it carefully enough to understand what it meant? She paused. That depends on whether anyone flagged it as material. A 42-page 1968 document in a county with dozens of active farm parcels. It's possible it was reviewed and considered minor, or it's possible it was noted and not fully analyzed. She leaned back. Either way, it doesn't change what it says. If it's enforceable, and I believe it is, then the rent adjustment mechanism in the 1968 document governs, not what Meridian sent you. What does that mean in actual numbers? She pulled out a notepad. The USDA cash rent survey for the county over the prior 3 years showed an average of roughly 1% annual increase. Under the 1968 formula, a permissible rent adjustment would be in the range of $11 to $12 per acre, taking Dennis from $285 to roughly $297, not $399. The difference was $102 per acre. On 200 acres, that was $120 to $400 per year. He didn't own the land, but he understood the agreement. Margaret sent a formal letter to Meridian's legal team in the 3rd week of April. It was 6 pages. It laid out the recording history, cited the specific language of Section 11, referenced the chain of title documentation, and formally rejected the proposed lease amendment as inconsistent with the governing rent adjustment mechanism. It requested confirmation that Meridian would honor the terms of the recorded covenant. It also included a complete copy of Book 214, page 37. The response came 12 days later, not from Garrett Bryce, from a different attorney, a firm in Chicago Dennis hadn't heard of. The letter was 3 paragraphs. It argued that the 1968 document was a historical artifact, that its provisions had been superseded by subsequent lease agreements, and that the clause was unenforceable under current Illinois landlord-tenant law. Margaret read it twice, then called Dennis. "They're not conceding," she said, "but they're also not telling me the recording doesn't exist. They're arguing about enforceability, not about the document itself. That's a different argument, and it's a weaker one." She researched Illinois case law on covenant running with the land over the following week. She found 3 relevant decisions, all of which supported the general principle that properly recorded covenants survive ownership transfer unless explicitly extinguished. None of the 3 cases involved agricultural leases specifically, but the legal standard was clear. She drafted a response. This is where most people assume there was a courtroom, a dramatic hearing, lawyers in suits making speeches to a judge. That's not what happened. What happened was a second round of letters, then a phone call between attorneys, then a request from Meridian's counsel for a 30-day extension to conduct additional title review. Margaret told Dennis that was a good sign. They're going back to look at what their title company actually found, she said. They may not have fully understood what they acquired. During those 30 days, Dennis kept farming. He planted his corn acres. He renewed his operating line. Tom Hensley agreed to a conditional approval pending lease resolution, which was the best he could do. Dennis didn't sign the Meridian amendment. He didn't ask for a buyout either, though Bryce called him personally in the 3rd week of May and offered one. A lump sum payment to walk away from the lease, 5-year term, calculated at a premium to current value. It was real money. Enough to retire, or nearly. He thought about it for one evening, ran the numbers, thought about what he'd do the morning after he cashed the check. Then he told Bryce he wasn't interested. This wasn't sentiment, this was a calculation about what he was worth as an operator versus what the land was worth as a passive payment. He'd spent 23 years building a farming operation on that ground. The buyout was a one-time event. The lease, if enforced, was a structure he could operate inside for the foreseeable future. Would you fight a corporate owner? Or would you take the check and go? The title review came back in early June. Margaret didn't get a copy of it. She wasn't entitled to see Meridian's internal documents, but she didn't need to. The response letter told her everything. Meridian's counsel acknowledged the existence and recording of the 1968 Master Agricultural Lease revision. They did not concede enforceability, but they proposed a settlement framework. Rent adjusted to $297 per acre for the upcoming lease year, with a new 5-year agreement incorporating an indexed escalation clause tied to the USDA county survey average. Adjustments capped at 6% per year, requiring tenant consent above that threshold. It was, structurally, what the 1968 document said, packaged in modern legal language, with a slightly higher cap than the original formula, but within range. Margaret called Dennis and read him the key terms. "That's basically a win," she said. "Basically? You're not going to get them to write a letter that says they were wrong, but the rent is $297. The escalation is indexed. The 5-year term gives you planning certainty." She paused. "The other tenants on adjacent parcels, the ones who didn't have the clause, they're signing the 399th amendment. Some of them have already signed." He thought about that. Thought about the farmers he'd sat next to at the Holiday Inn meeting, the man who said he was going to have to walk away. "Send the acceptance," he said. The new lease was executed in late June. Dennis mailed the signed copy back to Meridian's legal team in Chicago. He kept a certified copy. He had Margaret record a memorandum of the agreement in the county deed chain, which was her suggestion, and a good one. Paper has a way of losing itself over time. Recording it meant the next owner would find it too. He drove to the bank the following week and met with Tom Hensley. Laid the signed lease on the desk. Tom looked at the rent figure, looked at the escalation terms, looked at Dennis. "You're back above 125, Tom said. "I know. I'll take this to committee this week." The operating line renewed in August. Dennis bought his fall inputs in September. He planted winter wheat on 300 acres in October, the way he did every year. The fields looked the same as they always had. He didn't own the land, but he understood the agreement. Here's what the story is actually about. It's not about a hedge fund doing something wrong. Meridian sent a rent increase letter that reflected real market data. Their attorneys made a defensible argument. These things happen. Ownership changes. Markets move. That's how it works. What saved Dennis Carver was not luck. It was not a legal loophole. It was a 23-year-old lease that he read before he signed it, and a 42-year-old recorded document that he found before the deadline. He didn't find the 1968 clause in a moment of inspiration. He found it because he went to the filing cabinet instead of signing the amendment, because he had the instinct, even under pressure, to read what he already had before he accepted what someone was offering him. Most of the other tenants in that county are now paying $390 per acre. Some of them are going to have difficult conversations with their lenders this fall. Some of them signed without fully understanding the pressure they were under. That's not a story about corporate villains. That's a story about margin and cash flow and what happens when a cost structure shifts faster than an operation can absorb it. Would you even know what your lease says? Most people don't. Not the full thing, not the exhibits, not the recorded covenants. Cash rent doesn't care about loyalty. The bank's DSCR doesn't adjust for goodwill. The county recorder's office doesn't call you when something important gets filed. These systems don't protect you automatically. You have to read the paper. Dennis will tell you the same thing if you ask him. He's not a hero of this story. He's a farmer who kept his files organized and hired a competent local attorney before he needed one. The clause did the work. He just found it in time. There's a line that's worth repeating because it's the whole lesson. He didn't own the land, but he understood the agreement. That's not a small thing. In farming, in business, in any long-term arrangement involving land and capital and time, understanding your agreement in full before you need it is the difference between having a position and not having one. The 1968 document is still on file. Book 214, page 37. Right where Raymond Holst put it 57 years ago. It outlasted 3 ownership structures, 2 estate settlements, and 1 hedge fund acquisition. It will outlast whatever comes next. Ownership changes, paper stays. If this story helped you think differently about your own agreements and what might be in them, hit subscribe and drop a comment below. Would you have found that clause? Would you have gone to the filing cabinet, or would you have signed the amendment? Because the answer to that question is worth knowing before you're the one sitting at the kitchen table with a letter that doesn't make sense. He didn't own the land, but he understood the agreement.